Applicable law. Contracts for the sale of goods are governed by the Uniform Commercial Code, UCC. Goods are defined as movable, tangible things identifiable at the time of delivery. All other contracts are governed by the common law. Formation. This raises the issue of whether Bob, B, and Sam, S, entered into a contract. The formation of a contract requires mutual assent and consideration. Mutual assent. Mutual assent requires offer and acceptance. Offer. An offer must evince an objective intent to enter into an agreement, lay out sufficiently certain and definite terms such that the contract is capable of being enforced, and must be communicated to the offeree. Under the UCC, the key term for an offer to be sufficiently definite is the quantity term, and all other terms may usually be filled in by the court. Advertisements are not typically treated as offers. Acceptance. An acceptance of an offer may be made by any means reasonable prior to the offer's termination. Consideration. Consideration, the final element of contract formation, requires that there be 1. A bargain for exchange, 2. Of legally valuable detriment. A bargain for exchange requires the promise induce the detriment, and the detriment the promise. To be of sufficient value, the detriment need not be economic, or even very large. Statute of frauds. Even where a contract is formed, it may not be enforceable if it falls within the statute of frauds, and no exception applies. Among the contracts covered by the statute of frauds are goods sale contracts, where the price paid is $500 or more. Sufficient writing, UCC. To satisfy the statute of frauds, there must be some writing evidencing the existence of a contract, and its essential terms, which is signed by the party against whom it is being enforced. Exceptions to the statute of frauds. The UCC contains certain exceptions to the statute of frauds which we may argue make the agreement enforceable. These exceptions include 1. Where one party has partially performed on the agreement, but only to the extent of that partial performance, 2. Where promissory estoppel applies, 3. Where the contract is for specially manufactured goods, after substantial performance has begun and the goods cannot reasonably be resold, and 4. A merchant's confirmatory memo. Merchant confirmatory memo. Under the UCC, where one party sends a signed writing memorializing their oral agreement, and the counterparty does not object within 10 days, the counterparty will be deemed to have accepted, and the writing may be used to satisfy the statute of frauds. If the party orally accepts, this will also satisfy the statute. Merchant. The UCC defines as one who deals in goods of the kind sold, or otherwise holds himself out as possessing specialized knowledge, skill or expertise in such goods. Dead Man Act. The facts do not state if the jurisdiction in question has a Dead Man Act. This kind of act generally precludes the use of oral statements of a deceased against the descendant's estate to prove the existence of an agreement. Mailbox Rule. Under the mailbox rule, an acceptance is deemed effective when it is mailed. At this point, a valid contract is formed even if the offeror has not yet received the acceptance. By placing the contract in the mailbox, S has accepted the offer, and it became effective when he did so. Termination by death. An offer terminates by operation of law upon the death of either the offeror or offeree. Replevin. Replevin is a legal restitutionary, which allows a party to obtain a court order, even before trial in certain circumstances, allowing the party to retake chattels to which he has a lawful right. To be available under the UCC, the chattels must have been identified in the contract, the amount of time between contracting and the order being sought must not have been too great, and damages must be an inadequate remedy. Damages are inadequate where the subject matter of the contract is unique. The order must also be able to be enforced by the sheriff. Specific performance. Specific performance is a court order requiring a party to perform on a contract or face contempt proceedings. To obtain specific performance on a contract, the party must show 1. Certain and definite terms, 2. That legal remedies are inadequate, 3. That enforcement would be feasible, and 4. That the party has, or is willing to, fully perform its obligations under the contract. Expectation damages. Expectation damages are intended to place the non-breaching party in as good a place as they would have been had the contract been performed. Here, assuming C could not cover, the damages would be equal to the difference between the contract price and the market price of the car, plus incidental damages and consequential damages, less expenses saved. To be recoverable, damages must be sufficiently certain and calculable. Finally, a party must take reasonable steps to mitigate damages, although in a services contract they need not accept substantial. Illusory contract. For consideration to exist, each party must have obligations under the agreement. Future contingencies are sufficient to support consideration. Anticipatory repudiation. If the court instead found that the contract lasted until the task was completed, S would have anticipatorily repudiated the contract and would be in total breach. A party materially breaches a contract when they unambiguously give notice to the other party that they will not perform, and the agreement is executory. If this happens, the counterparty need not perform further and may sue. A party may elect not to accept the repudiation, but instead keep performing under the contract and wait until performance is due. Reliance damages. Reliance damages seek to place the party in as good of a position as they would have been had the contract not been made. Performance condition precedent. Generally, under the common law, a party performed by providing substantial performance. However, a condition precedent to a contract means that it must be strictly met in order for performance on the contract to be required. Courts typically construe provisions in a contract as promises rather than express conditions. However, an express condition can exist if it is clear that is what the parties intended per the contract language. Applicable law. Contracts for goods are governed by Title II of the Uniform Commercial Code. All other contracts are governed by common law. Goods. Goods are qualified as movable, tangible objects. Merchants. The UCC additionally has special rules for merchants. A merchant is someone who regularly deals with the types of goods that are the subject matter of the contract, someone who has special knowledge of such subject matter, or a business person involved in the transaction. Anticipatory repudiation. Anticipatory repudiation is when one party to a contract clearly and unambiguously informs the other that they will not or cannot perform the performance required by the contract. Upon an anticipatory repudiation, the non-repudiating party may either I. Treat the repudiation as a breach and sue immediately, 2. Treat the contract as rescinded, 3. Suspend performance until the repudiating party indeed performs, 3. Or wait and sue when a breach occurs. Contract modifications. While under the common law, a modification to a contract must be supported by consideration, the UCC only requires good faith to modify the contract. Request for assurances. Under the UCC, when a party has a reasonable suspicion that the other party may not perform, they may make a request for assurances in writing from the other party that they will indeed be able to perform as promised under the contract. Upon receiving a request for assurances, the other party must respond within a reasonable period of time, typically not to exceed 30 days, also in writing, with assurances that they will be able to complete their portion of the agreement. If a party fails to respond to a request for assurances, the requesting party may treat this failure as an anticipatory repudiation and take any of the options discussed above. Revocation of repudiation. In the event of an anticipatory repudiation, the breaching party may revoke their repudiation any time before the date of performance agreed upon on the contract, provided I. The other party has not rescinded the contract already, 2. The other party has not materially changed their position in reliance of this repudiation, or 3. The other party has not already filed suit for breach of contract. Impracticability. A contract becomes unenforceable if the subject matter of the contract is destroyed, the performing party dies, or the performance becomes illegal. Also, if performance becomes impracticable due to an unforeseen occurrence, I. The non-occurrence of which was an essential assumption of the contract, 2. That makes performance impracticable, and 3. The other party was not at fault. Cover damages. Compensatory damages are damages meant to put the non-breaching party into the position they would have been in had the contract been fully performed. Typically, these are determined by the difference of the market price and that of the contract, or the difference between price of goods purchased in the non-breaching party's attempt to cover and the contract price. A party only needs to put in an objectively reasonable effort in finding a reasonably priced product to cover. Consequential damages. Consequential damages are any damages that rise naturally out of the breach of contract that are not compensatory damages. These damages must be I. actually caused by the breach, but for the breach, these damages would not have been suffered, 2. foreseeable, and 3. relatively certain as to the amount. Incidental damages. Incidental damages are damages suffered by the non-breaching party in trying to remedy the breach. Reliance damages. Reliance damages are recoverable as the costs suffered by the party upon reliance of the contract and reliance that the other party would perform. Reliance damages and compensatory damages cannot both be obtained, and as such a party must choose between reliance and compensatory damages. Duty to mitigate. A non-breaching party must do all that is reasonably possible to mitigate damages and eliminate costs. The damages recoverable will be reduced by what has actually been mitigated, or what could have, should the non-breaching party fail to take steps. Governing law. The UCC governs contracts for the sales of goods, which are tangible, movable things. Common law governs all other contracts, including service and real estate contracts. Anticipatory repudiation. Under the UCC, if a party unequivocally expresses their intent to not perform their obligation under the contract, the party has anticipatorily repudiated, which entitles the other party to stop performance and sue immediately. Specific performance. Specific performance is a remedy in which the court orders the defendant to perform his obligations under the contract. This is usually available only for unique goods and for real estate transactions. In order for the court to grant specific performance, the following elements must be met: 1. Valid contract with clear and definite terms. 2. Inadequate legal remedy. 3. Feasibility of enforcement. 4. Mutuality of performance. And 5. No defenses. Valid contract. To be valid, a contract must have assent, offer and acceptance, and be supported by consideration. Misrepresentation. Misrepresentation is a defense in which case the party seeks to either rescind the contract or argue that the contract never existed because there was no meeting of the minds. Misrepresentation applies where a party 1. Makes a misrepresentation, 2. About a material fact, 3. With the intent to induce reliance, and 4. The other party actually and justifiably relied. Unilateral mistake. Unilateral mistake is generally not a defense to a contract. A mistake exists where the party is mistaken about a material fact that is a basic assumption of the contract. If the non-mistaken party knew or should have known that the other party was mistaken, the court will allow the contract to be rescinded. If the other party knew the other was mistaken, then the court will allow the contract be reformed to reflect the intention of the mistaken party. Contract formation. In order for a valid contract to be formed, there must be offer, acceptance, and consideration. Under the UCC, conditional acceptance is not treated as an acceptance, rather it is treated as a rejection. Battle of the forms. In order for a valid contract to be formed, there must be offer, acceptance, and consideration. Under the UCC, conditional acceptance is not treated as an acceptance, rather it is treated as a rejection. Under UCC, for a contract between two merchants, offer does not have to mirror acceptance. However, any terms in the acceptance that vary the offer will not become a part of the contract unless 1. Both parties are merchants, 2. The terms are not material, and 3. No objection is raised to them within a reasonable time. Here, both the disclaimer, or warranties, and the limitation of damages are material terms, since the warranties go to the heart of the quality of goods being delivered, and the limitation of damages speak directly to the economic interests of the parties. Since one of the elements is not met, these terms are not part of the contract, and the default warranties and damages rules apply. Perfect tender. Under the UCC, failure to make a perfect tender of goods ordered is a breach of the contract that allows the non-breaching party to reject goods and cease performance. Once perfect tender is not made, the buyer is entitled to reject the goods, cease performance, and not pay. Warranty of merchantability and fitness. Also, a warranty of merchantability is implied if the seller is a merchant, stating that the goods are fit for their ordinary purpose, and a warranty of fitness is implied if the seller knows the buyer is buying the goods for a particular purpose and relying on seller to provide conforming goods. Cover/consequential damages. In general, where a seller breaches by delivering non-conforming goods, a buyer is entitled to seek cover by procuring the same goods on the market and recover the difference between the cover price and the contract price. However, consequential damages particular to a particular non-breaching party, are generally not recoverable unless the breaching party could reasonably foresee such damages at the time of contract. Incidental damages. When a contract is breached, the non-breaching party may always recover incidental damages, which are damages relating directly to the handling of the non-conforming goods. Rejection of replacement shipment. Ordinarily, when a seller breaches a contract by providing non-conforming goods, the seller has within the time for performance of the contract to cure the breach. Minor versus material breach. Breaches of the promises or covenants contained in a contract provide grounds for the non-breaching party to sue for damages. The ability to treat the contract as discharged on the grounds of a breach, however, depends on the nature and extent of the breach itself. A material breach does provide the non-breaching party with grounds to discharge the contract. A minor, non-material, breach does not. Whether a breach is material or minor depends on a determination as to whether the non-breaching party received the benefit of the bargain sought under the contract. Courts will address an assortment of factors in seeking to arrive at such a determination, including the hardship to the defendant, the reason for the breach, whether the breach was willful or inadvertent, the cost of remedying the breach, the ability of damages to remedy the breach, and the overall degree of completion at the time of the breach. If a promise or covenant is implied into a contract, courts will generally accept substantial performance as to avoid a breach. If a promise or covenant is express in the contract, generally literal compliance is required. However, even when dates are included in a contract, including construction contracts, courts do not construe time to be of the essence unless otherwise clearly stated. Anticipatory repudiation versus inability to perform. An anticipatory repudiation occurs when one party, in a fully bilateral executory contract, communicates explicitly and unequivocally that it will not be able to perform its duties or obligations under the contract. An anticipatory repudiation discharges the non-repudiating party's duty to perform, and that party can 1. Treat the contract as discharged, 2. Sue immediately, 3. Wait and sue on the contract date, 4. Attempt to urge performance by the other party. A prospective inability to perform is a statement, by one party to the other expressing doubts or reservations about a potential ability to perform an obligation or duty under the contract. It differs from an anticipatory repudiation in its explicitness and unambiguousness. Frustration of purpose. Frustration of purpose occurs when a supervening event, which was unforeseeable to the parties, and which neither party expressly assumed the risk of, frustrates the purpose of the contract, i.e., deprives the contract of value and benefit. Impossibility. Impossibility refers to the situation where a subsequent event, which was unforeseeable, which undermined a material element of the contract, or a basic assumption upon which it was formed, and which neither party assumed the risk of, has rendered performance of the contract, by one or both parties, impossible. One form of impossibility is illegality, occurring where the subject matter of the contract has subsequently become illegal after the contract was entered into. Damages, construction. As a general rule in construction contracts, builder can recover lost profits if the owner breaches prior to commencement of the construction. If the owner breaches during construction, the builder can recover the contract price, the cost of completion. Impracticability. Impracticability encompasses the situation where a subsequent event, which was unforeseeable, and has a material effect on an element of the contract, or a basic assumption upon which the contract was formed, and which neither party assumed the risk of, has rendered one party's performance extremely or unreasonably difficult or expensive. Courts, historically, have generally been unwilling to excuse performance under a contract due to the increased cost in performance unless such an increase is excessive and extreme. Mutual mistake. Mutual mistake applies when both parties are mistaken as to a basic assumption, material to the contract, upon which the contract was formed. Governing law. The UCC governs contracts for goods. The common law governs all other contracts, including contracts for services and real estate. The UCC has additional rules that apply when both parties are merchants. Contract formation. A valid contract requires an offer, acceptance, and bargain for consideration. Under the UCC, Goods that cost over $500 require that the contract be in writing to satisfy the statute of frauds. Anticipatory repudiation. A person who unequivocally states that they will not perform the contract before the time performance is required will have been considered to anticipatorily repudiate the contract. The other party who has not repudiated can treat this as a total breach and sue on the contract prior to the time of performance. Reasonable assurances for insecurity. Under the UCC, a buyer who has reasonable concerns or insecurity about the seller's ability to tender a good can request assurances that the seller will tender a good. The seller must offer the assurances within a reasonable period of time, generally no more than 30 days, or else the buyer who requested the assurances can treat the lack of assurances as a contract breach. The buyer has no duty to inform the seller that she is seeking to cover through the breach. Perfect tender. The UCC requires that goods be perfectly tendered. This requires that the products have no defects and that they are delivered by the date required. Expectation. Where a contract has been breached and the buyer is without the good and the seller has the good, the UCC provides that the buyer can receive expectation damages for the breach. This would place the non-breaching party in the position it would have been in had the contract been fulfilled. This can include the cost to cover and purchase the replacement good. Consequential damages. A breaching party can also be liable for the foreseeable indirect harm that results from the breach of contract. Incidental damages. A breaching party can also be liable for incidental damages, which cover the ordinary expenses the non-breaching party may have incurred in responding to the breach of contract. This includes the costs of inspection, the costs to return the non-conforming good, or the costs of negotiating with a new vendor to cover a good. Governing law. Contracts are governed by either the UCC or common law. The UCC relates only to contracts for the sale of goods. Valid contract. To have a valid and enforceable contract, there needs to be 1. An offer, 2. Acceptance, and 3. Consideration. Parol evidence rule. The parol evidence rule bars the introduction of an oral or written agreement which was made prior or contemporaneous to the execution of the contract and which contradicts or varies the terms of the integrated contract. Condition precedent. A condition precedent to performance is a term in the agreement that must be satisfied strictly in order for the party's performance to be due. If the condition never occurs, the party never has a duty to perform. A promise, on the other hand, only needs to be substantially performed under the common law in order for the other party's performance to become due. Although this does constitute a prior oral agreement, the parol evidence rule does not bar the introduction of evidence to show that there was a condition precedent to performance. This is one of the rule's exceptions. Statute of frauds. A writing is only required to modify an existing agreement under common law if the modification places the contract within the statute of frauds. The statute of frauds generally does not apply to services contracts unless they are not capable of being performed within 1 year. Pre-existing duty rule. The pre-existing duty rule holds that a promise to do what a party is already contractually or otherwise obligated to do is not consideration for a new agreement. The exceptions to this agreement are 4. 1. If a third party will perform the obligation. 2. If unforeseen circumstances have made it such that the performance would otherwise be excused. Or 3. There is a change in the amount or type of performance. Common law, unlike the UCC, strictly requires adequate consideration for a modification or a creation of a new agreement. Breach, minor or material. Under common law, a breach of contract occurs if a party fails to fully perform its obligations under an existing contract. However, in order to discharge the other party's obligation to perform its obligations, there must be a material breach. Impossibility/impracticability. Impossibility discharges performance if it would be objectively impossible to perform due to unforeseen circumstances. Impracticability discharges a party's performance if the performance has become extremely and unreasonably difficult and expensive as a result of unforeseen circumstances. Compensatory damages. Compensatory damages in contract are aimed to place the plaintiff in the position that he expected to be in but for the breach. This is the general measure of contract compensatory damages. In order to recover compensatory damages, the damages must be shown to be 1. Caused by the defendant, 2. Foreseeable, 3. Unavoidable, and 4. Certain. Specific performance. Specific performance is an equitable remedy, which requires the contract to be performed. To be granted, it must be shown that 1. There is a valid, certain, and definite contract. 2. The plaintiff's conditions for performance were met. 3. There is not an adequate remedy at law. 4. Enforcement is feasible. And 5. There are no defenses. Unclean hands. Unclean hands is an equitable defense which says that the contract should not be enforced in equity if the plaintiff committed wrongdoing in the transaction.